Okay, so we are recording on Zoom, and so for those of you watching this after we record it, I'm gonna record a podcast episode here with Tom and Paula Roman from Roman and Roman. I'm gonna record their introductions later, so if you want to hear their introductions, then you got to go over to where the podcast is on any major podcast player and listen to this episode, which I think is going to be 266. And then you'll hear their biographies here, their introductions here, which are pretty impressive. So I would encourage you to do that, not only to get some download numbers for the podcast, but also to hear their great introductions. So Tom and Paula, if you guys are okay, what I'm going to do is start recording the audio, and then we'll just start jumping. We'll jump into the questions. You guys ready?
Ready.
So thank you to my guests, Tom and Paula, for being on the podcast this week. Welcome.
Well, thanks for having us.
Thanks for having us.
So we talked about a couple of different things, a couple of different questions that we wanted to talk about, but two that sort of caught my attention right from the beginning. And so I'll jump into those as well. One was something that Tom suggested, which was about dog bites in Florida and the liability of dog bites, the landlord's liability, the tenant's liability, the homeowner's liability. And the reason that this is stuck with me, I graduated law school from Cumberland up in Birmingham, Alabama. I graduated a couple of years after you guys did, and I graduated in 1998. But one of the papers that I had to write in order to graduate law school was all about Florida's dog bite laws. And so if I recall, in 1997-98, the way the dog bite law worked is that the owner could escape liability if they posted some kind of sign that said, "Warning, bad dog," or something like that. And that's what I vaguely remember about a paper I wrote 20 plus years ago. Do you know if that's still the state of the law in Florida for dog bites?
Yes, it is. It's still the law, but you're not going to see that too frequently. At least we don't in our practice. In all the years that I've been practicing, we have not had a case come up where there was an issue about a beware of dog sign. Most of the ones that come up are in situations where a tenant or a homeowner has a dog and it simply bites somebody, and the tenant or the homeowner, they weren't expecting the dog to bite somebody, but it did. And then our client was injured. And as you know, Sean, from your having dealt with this originally while you were in law school, that it's strict liability in Florida, which means that it doesn't make any difference how careful the owner was of the dog in having it on a leash, in keeping it away from other people or other dogs, that if the dog bites somebody, scratches somebody, otherwise injures somebody, then the dog owner is strictly liable for that.
And it doesn't really matter if the dog had a history of biting or had a history of being calm or mean, or what? Does that matter?
Well, it matters in negligence cases, but not in strict liability cases. So, for example, in a situation where a landlord has a tenant and the landlord knows that there's a dog there, the landlord's not strictly liable if that dog bites somebody. However, if the landlord knew or should have known that that dog was aggressive, perhaps from what he was told, from what the landlord had observed, then the landlord could be responsible on the negligence theory.
Okay. Well, and I know that, so we were introduced by Rich Fika, who owns Florida Coastal Insurance, and he's been a guest on the show before as well. Is this something that someone could approach Rich and buy insurance to protect against any kind of loss?
Yes, depending upon whether the dog has had a problem in the past. bitten people in the past, or depending on the breed of dog, a lot of the insurers are leery about providing insurance where a dog might be a pit bull, for example, or if the dog has bitten somebody in the past, it's probably going to be very hard to get dog bite coverage.
Okay. Okay. I understand. Well, thank you. That's brings back some memories of trying to escape law school and researching Florida's dog bite statute to do it. The other question I wanted to ask is kind of a personal question, and it's this concept of you can still get charged with a DUI even if you've been rear-ended. So you're drinking, you make the unfortunate decision to get in the car and start driving, you get rear-ended, and you could still be charged with a DUI. And the reason that this is interesting to me is I was talking to my mom, and my mom broke her shoulder a couple of months ago, and she's fine. She was in a sling for a while, been doing physical therapy. Everything is fine, but the pain medicine the doctors were giving her, it was codeine, and she does a lot of work. She has therapy dogs, she has therapy birds, and she does a lot of work with first responders. She lives up in Tallahassee, which I know you guys don't necessarily like that city, but she's lives up in Tallahassee. And so the police that she knew were warning her, hey, look, you don't want to take codeine. And even if you're okay to drive, if you have codeine in your system and you get into a fender bender, even if someone hits you, the cops can take you away for driving under the influence. And here I can imagine my 72-year-old mom getting hauled away on a DUI. But I guess that is really a thing.
Oh, yes, it is. Go ahead, Paul.
No, yeah, the bottom line is, don't drink and drive. Being on prescription medication, certain ones, even Xanax, would be something that you would be concerned about, especially if you're, for example, if you're rear-ended and you're seriously injured and you're at the hospital and we're doing blood work and these drugs come out on a drug screen, that could be an issue. So, moral of the story is refrain from using medications of that nature, or, drinking out for the evening, having one glass of wine with dinner, probably okay, but still got to be super careful.
Yeah. I think the bottom line, like you said, is don't take the risk, which is what my mom did. She just never took the risk. If she felt sore enough that she needed or wanted a pill, she would just have my dad drive her around. So I guess that's the bottom line. Well, thank you. Those two questions particularly just sort of stood out to me because of personal experience. So I wanted to be selfish and touch on them real quick at the beginning of the show. But really, the reason I wanted to talk to the two of you is from the perspective of the personal injury practice. And I don't do any personal injury. My practice, the focus of the podcast, is all about bankruptcy law and helping to get out of debt. But those two areas of law often intersect. And so in that vein, what happens if someone, from your perspective, I know there's issues from my perspective, which we'll get into from my area of law, but from your perspective, from your area of law, you pick up a new client, they say, I've been in a bad car accident, I need these medical procedures, physical therapy, whatever, in order to recover. But while I'm trying to recover, I can't work. And so what does someone do if they get injured and that causes them to lose their ability to generate income while they're recovering? What do they do? How do they get around that? Or do they?
Take that one. Well, first of all, in Florida, we have personal injury protection coverage on our motor vehicle policies that's required by our Florida no-fault law. Personal injury protection, we call it PIP for short, covers up to $10,000 of one's medical expenses and lost wages. It pays the medical expenses at 80% and the gross lost wages at 60%. So when someone comes in and they say, I can't work, or I've been out of work for a week and the doctor wants me to stay home another 2 weeks, we can attempt to reserve those personal injury protection benefits for lost wages and then submit lost wage claims to our client's insurance carrier, regardless of fault. This is the law. A lot of folks don't know that. They get surprised, but that's the law. Your carrier pays for those medical expenses first and lost wages. Let's say they're going to be in a longer period of time without work. They could be potentially fired. They could be if they don't go back to work. There's unemployment. Unfortunately, that's one avenue. We would want to look at our clients' coverages to see if they might have short-term disability for their employment or even long-term disability. But the lost wages, including lost earning capacity, is part of the damages that we seek from the negligent party in an accident case, whether it's a motor vehicle or a premises fall down case, that type of thing. But in a motor vehicle case, we do have that ability to get lost wages through our client's personal injury protection coverage.
And you said regardless of fault. So if I caused the accident, I can still get the PIP coverage from my policy, even though I was the one that caused the accident?
That is correct.
Huh, I didn't know that. So what happens if the injuries exceed the insurance coverage? Or what happens if someone gets hit by someone who is uninsured and they need to, and there's no coverage on the other side? What happens in a situation like that?
Well, one of the first things we do if we're retained to represent someone, for example, in a motor vehicle accident, is we send out letters to our client's insurance carrier, as well as to the other party's insurance carrier if they have insurance. If we don't know whether or not they have insurance, because perhaps there was nothing listed on a crash report, or maybe there was no crash report, we send letters out to that person to see if they have coverage. If they have no coverage, we look at our client's policy to see if they have something called uninsured, underinsured motorist coverage, which is used to compensate our clients for their damages. Damages being past and future medical expenses, past and future loss of income, they can't work, past and future pain and suffering damages. It's important insurance to have on your policy if you can afford it. If you purchase bodily injury liability coverage, which is not required under Florida law, then you automatically have underinsured motorist coverage on your policy. Unless you sign a rejection form, carrier is required to provide you a form to select lower limits or higher limits. And if you reject it entirely, then you don't have uninsured, underinsured motorist coverage. So that's important coverage. Not everybody has it. And unfortunately, based upon the statistics that I've seen on the internet, about 27% of Florida drivers are uninsured. That's why that's important insurance coverage to have if you can afford it.
And so uninsured, underinsured is coverage that I would buy. So if I'm hit by somebody in a car accident that doesn't have insurance or doesn't have enough insurance, then my uninsured or underinsured would kick in. So I'm in essence collecting from my own insurance policy, not the other driver's insurance policy. Is that accurate?
That's accurate to a point. If the other person has no bodily injury coverage, yes, then we're focusing on our client's uninsured motorist coverage, UM for short. If the other side has minimal bodily injury limits, but then the required amount, if you're going to purchase it, it's $10,000 per person, $20,000 per accident. So if that's all they have, and you've got a fractured femur, in addition to collecting the bodily injury coverage from the negligent parties policy, we're looking at our client's own policy for that UM coverage.
Okay. So what's the first thing you should do if you get into a car accident? And is there a difference if that car accident is your fault or someone else's fault?
Well, the first thing to do, regardless of fault, would be to call 911. You may be injured, I don't know, the other person could be injured, but calling 911 and reporting it and waiting for law enforcement to come to the scene is really important. Taking photographs, if you're able to, of the damage to both vehicles involved in the accident, or all vehicles, there could be three. If you're able to get information from the other driver involved, you want to get a copy of their driver's license, you take a picture with your cell phone. You want to get a copy of their insurance card and a picture of the license plate. And I've seen it where folks are involved in an accident, they don't have a police officer come to the scene, they think they're okay, they find out later they are hurt, but they didn't get the name or the driver's license of the person that was operating the car. They got a copy or took a photograph of the license plate. How do you prove who was driving the car? That can be difficult. So those things you can do if you're able to physically while you're still at the scene. And of course, moving your vehicle from the location where it is, if it's safe to do, if it's not safe to keep it there in the middle of a busy highway and you're able to move it over to the side of the road, that's important too. Stay calm, whether you're at fault or not at fault, stay calm. Limit your conversations with the other driver to collecting that important information. And then wait for law enforcement or EMS.
Okay. What if, and I've had a couple of people call me from time to time and ask, what if I'm the one that gets hit, but for whatever reason, the officer gives me the ticket? So let's say I'm making a left turn and I get T-boned by a car, but I was not making the left turn properly on the light. So I'm the one that gets the ticket. Is there any link between who gets the ticket and who's at fault from a personal injury perspective?
We have clients that get tickets in motor vehicle accident cases, and depending on the facts of the situation, we will fight that ticket in court if we feel particularly that it's defensible. And if the ticket gets thrown out, it improves the potential that we'll have a successful recovery in a settlement, and if we need to in litigation. It just depends on the nature of the situation. Even if a car is going through an intersection on a green light and it's speeding, it doesn't mean that the person that's making the left turn doesn't have to yield the right of way. But there's this issue of comparative fault. So some of these cases, depending on how significant are the injuries to the person making the left turn, we're able to procure tender of the policy on the driver that was going through the intersection. It just depends on what we can show to an adjuster about how the circumstances were that justify our client being not solely responsible for the accident.
Okay. Okay, that makes sense.
Back up to something real quick regarding what happens if there's no insurance. And we'll talk about motor vehicle accidents predominantly, but if there's no insurance or if the injuries far exceed the amount of the policy. So attorneys who do personal injury work do it on a contingent fee basis. That means that they advance the costs necessary to present the claim and to litigate the claim, and their fee is contingent, meaning it depends on the outcome. If there's no recovery, you don't owe the attorney anything. So in a situation like that, attorneys are, for the overwhelming most part, they will not proceed with a pre-suit claim. They will not proceed into litigation unless they know there is a deep pocket. And by deep pocket, they mean it's insurance coverage. So the negligent party generally has to have insurance coverage that make it worthwhile for that attorney to wait to get paid until there's a recovery in a settlement or through a trial, litigation. So if there's no insurance, what's the likelihood that an attorney is going to pursue the claim? It's not going to be terribly likely, but most attorneys, or at least our firm, does this, and I think most attorneys do, they will do background check on the potential defendant, and they will see what they own. That's in the public record. So, for example, we can do a background check and find out whether the vehicle driver has multiple vehicles, has boats, has planes, has real estate, or has a mortgage on somebody else's property, and they're receiving payments on that. So we can find out, and that's a good thumbnail sketch about whether the defendant may be collectible, even if the policy limits of the defendant, driver, or car owner are low, or maybe they just let their policy lapse inadvertently. Um, I just filed a lawsuit yesterday in a case where there's no insurance, but I have reasonable expectation that the defendants are recoverable. So we do proceed in that direction, but it's not on a regular basis. It just depends on the situation.
Yeah. And I've said that to clients on my end as well, in terms of collection, in terms of real estate litigation, some of the other stuff I do, is that we also, not only do we have to weigh the merits of whether legally we can prevail in the case, but we also have to weigh the merits of, once we prevail, $1 million judgment and a $1 judgment. If the defendant doesn't have anything, you're going to end up with the same amount of money in your pocket, which is zero. But that does bring.
Sean, let me just ask you, you had brought up the issue about what happens if somebody's out of work due to an accident. And I think for the most part, we're talking about like a serious motor vehicle accident as opposed to a dog bite, or a serious fall down accident where bones are broken and the person cannot do their job.
Right.
Under those circumstances, a lot of the doctors that practice in the area of personal injury law will wait to get paid until the case resolves. It doesn't mean that they're not owed the money. They're still owed the money even if there's a negative result, but they will wait to get paid. And not every doctor will do this. For example, doctors that work with managed care, they take health insurance, Medicare, Medicaid. They do volume business and they cannot wait to get paid. So they're not the doctors that a personal injury client should be going to see in the event of an accident. They should generally see doctors that practice in personal injury cases on a regular basis, who are prepared to testify in court, prepared to have their deposition taken, prepared to say whether or not the injuries from this particular accident were caused by this accident or were pre-existed or maybe were due to a subsequent accident. So that's important for somebody that may be unemployed due to their accident. They can't go back to work for a while, but they have a nest egg that they can rely on, but bills are mounting up. So the doctors can wait to get paid if they see those types of doctors. But in a situation, you're a bankruptcy attorney, what avenues are available for somebody? We don't want a client, for example, to file Chapter 7 bankruptcy in the middle of a personal injury case, but what avenues, if any, are open for reorganization? Is there a Chapter 13 or a Chapter 11 that could be pursued for somebody under these circumstances?
Yeah, and if I recall correctly, what you're talking about is the providers being paid later. Those are called letters of protection, or you get letters of protection that basically say that the medical personnel are going to be paid later. Am I using that term right?
We simply ask them if they'll wait to get paid when the case resolves, either through settlement or trial. And doctors that practice regularly in this industry understand that, and they will do that.
Okay. Well, and then, yeah, to answer your question, where my area, where bankruptcy really intersects, the issue is when somebody files bankruptcy, all of their assets become assets of the bankruptcy estate. So in a Chapter 7, if I were in a car accident that was not my fault and clear liability on the other side, insurance policies, the whole 9 yards, if I file bankruptcy, then the right to sue within the personal injury lawsuit, the lawsuit itself now belongs to the bankruptcy trustee. And what a lot of personal injury attorneys are afraid of is that if the client files bankruptcy, the bankruptcy trustee will take over. And it is the bankruptcy trustee's right to take over, say to you guys, thanks for bringing the case this far. You're out. I'm bringing in my other buddy who's a personal injury attorney, and now they're going to get paid on this case. And I think that's what a lot of attorneys are scared of. And it happens in a lot of cases where Chapter 7s are filed. I know that I can never promise this to any attorney, but I know that there have been some cases, depending on how far along the personal injury case is, that I can convince the trustee to allow the existing personal injury attorney to remain on the case, finish out the case, and then to the extent there's any payout there, then it goes to the bankruptcy estate. We file the settlement papers so that the judge approves the payout to the personal injury attorney. So there is a way to navigate it, but it is risky for both the debtor, the person that was injured, the person filing bankruptcy, and their attorney, because there's no guarantee that I can keep the case with a particular attorney. And the bankruptcy trustee really only cares about getting money to pay to the creditors. They don't necessarily have the emotional investment in the client that someone like you would have. You know, they don't have that emotional attachment to the case, emotional attachment to the client. They're still going to do their job. They're still going to do the job as best they can. But obviously, as the bankruptcy attorney, I want to try to keep the case with the attorney that brought the case, researched the case, filed the case. And so you're right. One other way to get around that, we could file a Chapter 13, where a Chapter 7 is a liquidation. Chapter 13 is a reorganization. So what we would do is we would say, okay, we've got this personal injury case. The anticipated value of the personal injury case is X. And so what we're going to do is, bankruptcy trustee, we're going to let the existing attorney continue to push that lawsuit. When that lawsuit settles, or resolves, whether through trial or settlement or mediation or whatever, we'll file the necessary settlement documents in the court. The attorneys will get their fees. The rest of the money will go into the bankruptcy court, and the bankruptcy trustee will then use that money to pay creditors. But it's a lot more structured. The debtor keeps control. So you're right. If somebody is in an accident and they feel that bankruptcy is the way to go, and they're in the middle of a lawsuit, I would probably advise them to do a Chapter 13, a payment plan, over a liquidation. Chapter 11s are a little bit more complex. They're also reorganizations, but they're probably, I don't know that we have a lot more time to go into Chapter 11s. I would just say, if someone has questions about the difference between 7, 13, and 11, give me a buzz. But if you're in an accident and you feel like bankruptcy is a necessity, first thing I would do is consult with the personal injury attorney that's handling the case. But probably I would recommend a 13 over a 7. So,
Sean, what about a case where someone settles their personal injury case, and then decides afterwards they need to file bankruptcy to get rid of other debts that they had accrued prior to being in their car accident? Is there a certain period of time that they should wait to file bankruptcy after settling the personal injury case, so as to avoid the loss of what they had obtained by way of a settlement?
yeah, if it's based on a court order, then I don't believe so. In other words, if there's a court order or a court settlement that says these medical providers get paid in this amount, the attorneys get paid X in this amount, the injured party, the plaintiff, gets X amount of dollars. In that situation, we've already got a court order. And so the bankruptcy court is not going to overturn an order of the state court. They would have to accept that order. And so the only piece we would be dealing with in a bankruptcy in a scenario like that is the piece that goes to the debtor, the plaintiff, the injured person. If there is no court ordered settlement payment, then I think the period of time is 90 days, is 3 months, is the look back period. And of course, I like to be an open book to the bankruptcy court. I don't want to risk, doing something improper within the bankruptcy court. So I'm always going to be an open book. And even if we had to file within the 90 days, as long as I can show the bankruptcy court, here are all the agreements with the medical providers, here's the retainer letter maybe with the personal injury attorney, here's this, here's that. I don't think the bankruptcy court is going to get to, or the trustee really is going to attack some of those previous settlements, because that's what had to be done. The medical providers had to be paid. The attorney had to be paid. And as long as it's a reasonable amount. The other thing I might coach the plaintiff to do, the injured person, the debtor to do, is spend that money wisely, spend that money correctly. In other words, don't go out and prepay, a year's worth of rent. Don't go out and prepay a year's worth of car payments. Don't go out and buy, big screen TV and, this and that and the other thing. But, if we can use that money and spend it down over time, then there's nothing wrong with filing bankruptcy after that. The other thing that I might suggest is if it's a big enough settlement, a lot of times that then allows us to avoid bankruptcy altogether. And so we can take that money and call the creditors one by one and, okay, Discover, I know you're owed 10 grand, but would you take 4 and go away? Okay, Visa, I know you're owed 5 grand. Would you take $1,500 and go away? And we don't necessarily have to disclose everything they're getting in the personal injury settlement in order to settle with the creditors one at a time. Like I said, we have to be an open book with the bankruptcy court, but we can talk to the creditors one at a time and say, okay, I know you're owed X. Will you settle for this? And I've been doing this for a while where I know, for example, Discover is around 60%, give or take. American Express is tough. They're 80, 90% of what's owed. Some of the others, Visa, MasterCard, some of those other bank cards, my average is around 30 to 35%. Of course, typical attorney disclaimer, that doesn't mean in every case it's going to be that way. But a lot of times, yeah, if we get a big personal injury judgment, we can use that money to settle with the creditors one by one and even avoid a bankruptcy. So that's a strategy I like to do a lot. Sort of in this same vein, one of the other questions that I had was, I get a lot of times the internet lawyer, the one that researches on the internet. What happens when someone says, well, if I don't hire you all, then I can save, 40% that's going to go to you when you win the lawsuit. I can save that 40% and I can put it in my pocket by doing this myself. How do you respond to that type of an objection?
I would caution anyone to try and represent themselves in a personal injury case without at least first consulting with a personal injury attorney so that they can find out what their rights and responsibilities are as an injured party in an accident case. One of the important things I think that a lot of folks don't realize and don't think about, if they have having personal injury protection benefits is one thing. When you reach a settlement with the negligent party, their carrier, they get a credit. The negligent party gets a credit for that $10,000 of PIP benefits that have been paid. But if you have had medical bills paid by your health insurance plan, or if you're a Medicaid beneficiary, you have Medicaid that pays bills, or Medicare that pays bills, the health plan, Medicare, Medicaid have liens against any settlement or recovery down the road that you obtain. And that's with regard to Medicare and Medicaid and most health plans, that's regardless of whether you're getting money from the bodily injury settlement or from your underinsured motorist carrier. So as a personal injury attorney, it's our responsibility to communicate with those health plans, Medicare, Medicaid, to find out what's been paid that was towards the accident-related medical bills, and then to satisfy those liens out of recovery. Medicaid typically gets paid back 100%. So what it pays, there's formulas that are applied with respect to most health plans and Medicare. And I don't think that the average layperson even has a concept of what's the first thing to do. One of the worst things that can happen is you settle your case by yourself, you don't pay anybody back, you lose your Medicaid benefits. That could be devastating to somebody who's on public assistance. Lose your SSI, supplemental security income. If that was your only income, you could lose Medicare coverage for a period of time. And you could lose your health plan. So that's one important aspect of why you want a lawyer. Also, I think that when you have an attorney involved in a case, the insurance adjusters on the other side, and even on your underinsured motorist coverage side, may look at the case differently. I think they try to get away with paying less if somebody's unrepresented. Sometimes they've even shown up at the door shortly after the accident with a small check to try and encourage the person to settle. And that's not something you want to do. You don't want to sign any paperwork by any means without having an attorney look at it. So
look at also in motor vehicle accident cases with personal injury protection coverage, which, as we talked about, generally it's going to pay 80% of the medical bills. The doctors won't wait to get paid on the 20% unless they have some assurance from legal counsel that they'll get that money down the road. So somebody that is unrepresented that needs, first of all, need to find a doctor that isn't prejudiced against people who are injured in accidents. Like we said, managed care doctors, your primary care doctor, they're not generally interested in doing this. And you might find yourself picking a doctor that mostly testifies in court for insurance companies. So it's probably better to have an attorney to make sure you're going to the right doctors that aren't prejudiced against personal injury victims, and that can give the doctors the assurance that they'll get paid their 20% of their bills when the case ultimately resolves. Somebody unrepresented, they don't have that ability to do that.
Yeah, and I completely agree. And I threw out 40%. That was my number. I don't know what your fees are. I don't need to know what your fees are. I don't need you to quote them on the show here. But a lot of times I've found in not only personal injury situations, but in almost every situation, the fee that you pay to the attorney is going to come back and generate more for you in terms of even just the experience. I mean, I go back to the concept of, I can change my own oil, but I got other stuff that I want to do. I can mow my own lawn, but I got other stuff I want to do on the weekend to hire somebody to do that. I can file my own tax return. My dad's a CPA, so why do I want to take the time to mess with it all when I can just give it to a 50-year plus experienced CPA? And so I think that's a factor too, especially even on my end where people say, well, I can go on the internet and file bankruptcy. Well, yeah, you can, but if you make a mistake, you could lose all your stuff potentially to the bankruptcy trustee. So I agree. I want to jump back. So one of the other areas where I think bankruptcy and personal injury intersect, and one of the things that you may or may not like me for anymore, when a personal injury judgment gets entered. So now you get a judgment against the at-fault driver, and the at-fault driver has no insurance, has run out. They don't have coverage, or they don't have enough coverage. And now you get a judgment against them personally, and they don't pay it. I know that Florida has a law that has some consequences to somebody that causes a motor vehicle accident and doesn't pay the judgment. You want to talk about that for a bit?
Well, going back just a little bit, if you cause an accident and you hurt somebody, if you're uninsured, or if you have insurance and you just have the basic personal injury protection and property damage coverage, but no bodily injury coverage, you can have your license suspended by the state of Florida. You can apply to have it reinstated by paying a reinstatement fee and showing proof that you've obtained the minimum amount of bodily injury coverage, which is the $10,000 per person, $20,000 per accident. Or you can post a bond in that amount. Then you can get your license reinstated. So even before you get to the point where you've been sued and there's a judgment against you now, and what happens if you don't pay the judgment, your license may already have been suspended if you didn't have that bodily injury coverage and you caused injury to someone else as a result of your negligence. If you have bodily injury coverage and you are sued, that would typically be a case where your insurance company, for whatever reason, denied the claim, maybe on the basis of liability. Maybe the injured party was partly at fault. That's called comparative negligence. Maybe the insurance company, your insurance company, looked at the injuries of the other person and determined that, these were due to the other 3 accidents that they've had, not this accident, or their damages just don't amount to what they're claiming they should be. So perhaps your insurance company denied the claim when they could have paid the policy limits to the negligent party. Now you're in a lawsuit. Well, the good thing about having bodily injury liability coverage is that your carrier pays for your legal defense, hires a lawyer and pays for the lawyer to defend you. But regardless, if the outcome is negative and you have a judgment against you, in that type of scenario, there's something called bad faith that can be asserted against your own insurance company. And you can sue your insurance company for bad faith if they could have and should have settled the case when they had the ability to do so, and would have spared you being sued and getting a judgment against you. In that type of a case, what happens then is you may be contacted by the plaintiff's attorney and asked to assign your bad faith claim to the plaintiff. That gets the bad faith attorney involved, who then takes over and may go ahead and file what's called a bad faith lawsuit against your own insurance company to get the judgment satisfied. And that spares you from having that judgment on your record. So that's one way that that judgment could go away, potentially. The other way the judgment might go away would be perhaps, so I have to hand that over to you, Sean. The person might be facing bankruptcy.
Right.
That's correct.
And I know there's been some, I don't know if litigation is the right word or whatnot, but there's been some, so the question is, in my world, if I file bankruptcy, that eliminates the judgment. Therefore, the suspension of the driver's license should be undone. But then there's the whole question of the bankruptcy stay applies. And so is taking the hold off of the driver's license an act in violation of the bankruptcy stay? And then flip that, is not doing anything, is asserting that suspension of the driver's license, asserting that control over the driver's license, is that an issue of the bankruptcy stay? So it is a little bit of a complex issue on my end. There's a handful of attorneys that I know I can call and negotiate with, and there's a handful of attorneys that I know that if you've got a judgment against you and it's from firm X, we've got to file bankruptcy. There's no other way. They're not going to negotiate. They're not going to do anything with us. So that's good to know that maybe we can use the bad faith claim as the carrot on the stick, maybe to help with the driver's license suspension. Do you all review? So if I'm not in a personal injury accident, I've got a clean driving record, will you all take a look at my policy to tell me if I've got the right coverages, or what things should I be looking for? We've talked about we've talked about PIP, we've talked about DUI, we've talked about other acronyms, but what are some things that I can look for in my insurance policy to make sure I've got enough coverage? Or is that something you all would do, is take a look at my policy and let me know where the holes may lie?
Yeah, we're happy to look at anybody's motor vehicle policy or their policy for their business or their homeowner's insurance policy. We're happy to look at them. Generally, obviously, if you can afford a low deductible or no deductible, that would be better. Because before, like in a motor vehicle accident case, where PIP pays 80/20, you could have a $1,000 deductible, and before your PIP coverage is going to start paying that 80% of your medical bills, you have to incur your deductible, which could be, like I said, $500 or $1,000. So the lower deductible or not having deductible obviously is better. You can't have uninsured motorist coverage if you don't have bodily injury liability coverage. So that's the way Florida law works. And you can't have more uninsured motorist coverage than you have bodily injury liability coverage. But you could have $100,000 bodily injury coverage, and you could have a lower amount of uninsured motorist coverage. But you can't have more. You can have equal to, but not more than that. So these are the types of things that we would like to look at in terms of somebody's policy. For uninsured motorist coverage, you can also have stacked or unstacked coverage. If you have more than one vehicle in the household, it's better to have stacked coverage. It does cost a little bit more, but it doubles your coverage. Also, there's something called medical payments coverage in motor vehicle accident cases on your insurance policy, and it generally will take the 20% that your PIP coverage doesn't pay of your medical bill. So that's something which is optional, but which you should have if you can afford it.
Okay. Excuse me. Sorry. Last thing I wanted to get into before we sort of wrap it up is going to trial. And so, two questions that I had about, a situation where insurance company just refuses to settle and it's got to get to trial. What are some of the risks to a plaintiff in taking the case to trial? And then the other thing that I've heard is that juries, and you can explain it. I don't think I'm going to ask the question properly, but juries either cannot be told that there's coverage in place or cannot be told the amount of coverage in place or something like that. So what are the issues in going to trial, and what can and cannot tell a jury?
Juries cannot be told about the fact that you have insurance unless you're suing your insurance company for your underinsured motorist coverage. So if you're suing the carrier, obviously the defendant is the carrier, but they won't know how much insurance you have. If you're simply suing an individual, the jury is not told that that individual has bodily injury liability coverage. They don't know the amount, and they don't know if they have coverage, and they don't know that you have personal injury protection coverage on your policy. They don't know anything about insurance. That's something that I think the average person might not be aware of. The jurors can certainly speculate that there might be coverage, but it's not mentioned.
Do you know the logic behind that? Is it because we don't want juries to grant judgment where there is insurance, or do you know if there's, I don't want to get into my opinion of our legislation, our legislators, but do you know the reason behind that?
It could persuade the jury one way or the other. It would be prejudicial to mention that someone has insurance. Oh, they have insurance, then hey, we can enter a judgment against them because they have coverage. That's not. They have to look at the facts of the case and not consider anything outside of what they hear before the court. Okay. So it's not probative. It's prejudicial, and that's the basis for why it's not mentioned.
Well, that's what insurance companies have been able to accomplish. It's not something that, as plaintiffs' attorneys, that we think is a good idea. But the insurance industry has a pretty good lobby, and this is simply the status of the law as it is now. So.
Yeah, like I said, there's some things that people complain to me about, and really the only explanation I have is because that's the way the legislation is written, and if you don't like it, you got to go to your representative and ask them to see if they can change it. So I get it. So what are some of the, if I'm a plaintiff, what should I be evaluating in terms of whether to go to trial or not?
Well, there's three aspects to any personal injury case: liability, who's at fault, damages, what are my damages, my medical expenses, do I need care in the future, pain and suffering damages, and also then the link, which is causation, is the other issue that has to be considered. So in a lot of cases, there's issues with liability, and maybe the plaintiff was partly at fault. If a jury agrees with the defense that the plaintiff is partly at fault, then any verdict in favor of the plaintiff will be reduced by the percentage of negligence that the jury assigns to the plaintiff. So that's something that we have to consider when determining proceeding with filing a lawsuit. Also, did this accident cause these injuries that our client is complaining of? And that's where we rely upon our inspection of medical records, treatment prior to the accident, any history of prior accidents with the same injuries or complaints. And the other part of the damage is we have to have a medical expert in a motor vehicle accident case identify and state within a reasonable degree of medical probability that this person sustained a permanent injury in order to recover damages for pain and suffering. So that's another aspect of the case. So we look at all of those aspects, all of those issues, and discuss with our client whether it's advisable to proceed with filing a lawsuit if we're not able to get the case settled on a pre-suit basis. Also, if we proceed with litigation because of our rules of civil procedure and statutes, if our client loses or if they win but they don't win enough, they have potentially end up paying the other party's attorney fees and court costs, taxable court costs. So they could even in the case where they win, they could end up with a judgment against them and end up paying the other side for those expenses. So it's a risk to file a lawsuit in any case, but all these things have to be looked at before the decision is made to proceed with litigation.
Okay. Okay. Well, thank you. I appreciate that. Before we wrap up, first, thank you very much for your time today in recording. Is there anything that I missed? Is there anything that you want to add?
I'd like to add one thing to tell your viewers that if you're in a motor vehicle accident, under our current law, you have to see a doctor within 14 days, or you may be denied 100% of your $10,000 of personal injury protection benefits. So that's all the more reason to talk to a lawyer ahead of time, before you decide not to go with an attorney and to try and do it yourself. You do want to get checked out by a doctor if you feel that you have any injuries as a result of the accident. And the sooner you do that, the better, not only for your health, but also from a legal aspect of your case.
Well, and a lot of times your injuries won't manifest right after the accident. It'll take a couple of days until you really start to feel sore. So, yeah, I think that's always good. Even before that law was in place, I was in a car accident, and that was the first thing I did was I went to a doctor and said, check me out, make sure I feel fine, but make sure I'm going to feel fine a couple of days from now. So, yeah, I think that's a good idea. I did also want to give you an opportunity. I know the first time that I was exposed to your firm, I was running the 4th of July midnight run, which I know is sponsored by Kiwanis, and I know you all have been sponsors of that run, and I know you all have been involved in Kiwanis. So I want to give you an opportunity if you want to give Kiwanis a plug, if you want to give the midnight run. So for those of you outside of the Tampa Bay area, I'll let you describe it more, but it is exactly what it sounds like. It's a 5K, 10K race that starts right around midnight, going from July 3rd to July 4th. It's a fantastic fundraising event. It's a very fun event. I've run it a whole bunch of times. And I think this year, 2021, it's going back to being in person and virtual, right?
That's correct. It's a virtual run if you would like to run virtually, and it's also a live run. And so far we have quite a few runners that have signed up to actually do the live run. This will be our 42nd annual run. 42 years in the making for the midnight run. We've raised close to, I think it's even over $1 million for the local community. Kiwanis is an international organization, and there's Kiwanis clubs all over the world. We're members of course, of the Dunedin Kiwanis Club, and we really enjoy it. It's a lot of camaraderie, and you know that by doing this fundraising and participating in these community service activities, you're helping families in need. And primarily, what we are concentrating on is to help children and families in need in the community. We have a lot of projects with the local elementary schools as well. We have an adventure run every January on Honeymoon Island. And we just had our second annual golf tournament at the Chichi Rodriguez Golf Club.
Nice. Yeah, and I know the midnight run is also out in that Honeymoon Island area. We start prior to, and then we run, depending on the length, run to or onto a Honeymoon Island. And yeah, I plan on attending probably in person this year. I just got, as we record, I got my first shot yesterday. I'll get my second shot by the end of the month. And so my goal or my plan is to be there in person this year as well. So I love running that race. It's one of the most fun races I do. So great. Anything else before we wrap up?
Let me just add about the Kiwanis. You can actually see the dollars at work. Our Kiwanis Club teamed up with the city of Dunedin and built the Kiwanis Spray Park for children. If you know where that is, near the community center. We also built the outdoor fitness park called the Kiwanis Fit Zone in Dunedin as well. Those are two things that you can use. They're free, and that's what the proceeds from these events do. They go back into the local community.
Yeah, that's great. And I've got the website up here in front of me. The website for the midnight run itself is KiwanisMidnightRun.com. So just like it sounds, KiwanisMidnightRun.com. I'll put that in the notes. Again, if you want to contact Tom or Paula, their website is RomanRomanLaw.com, or you can email them at info@RomanRomanLaw.com. You can also find them on Facebook, on social media. So Tom and Paula, thank you again for your time. Thank you for being guests on the show today.
Thanks so much, Sean.
Thank you for having us.
Have a great day.
Thanks. So I think that'll do it for this week's episode. Like I like to say at the end of every episode, I hope that at the end of the month you have more money, and not at the end of the money you have more month. That'll do it for this week's episode, and we will talk to you in next week's episode of the Crushing Debt Podcast. Cool. So we're done there. And for those of you watching on video, thank you, and we'll see you later.